Welcome. I am Dr. David Vasquez Gonzalez. Today's quick pick is titled Legal Basis for the Education of English Learners. PaTTAN's mission. The mission of the Pennsylvania Training and Technical Assistant Network, PaTTAN, is to support the efforts and initiatives of the Bureau of Special Education and to build the capacity of local educational agencies to serve students who receive special education services. PDE's commitment to the least restrictive environment. Our goal for each child is to ensure individualized education program, IEP. Team begin with the general education setting with the use of supplementary aids and services before considering a more restrictive environment. Pennsylvania English language legislation. ESL bilingual programs are identified in the Pennsylvania School Code of 1949 in Chapter 4, Section 4.26 as general curriculum. The academic program for an L with a disability must consider ESL just as it must consider any other general curriculum services available to non-disabled students. Programmatic decisions regarding Ls with disabilities should be made by the IEP team with appropriate representation. It is not appropriate for an L with a disability to be denied access to general curriculum, including an English language instructional program. Special education services do not replace an English language instructional program. ESL bilingual guidance, federal law. 1954, Brown versus Board of Education. This case dealt with the desegregation of public schools. 1964, Civil Rights Act. This act prohibits discrimination on the basis of race, color, or national origin in the operation. This was the chief drive for bilingual education in the United States. 1968 Bilingual Education Act. The Title VII of the Elementary and Secondary Education Act established federal policy for bilingual education for economically disadvantaged language minority students. It allocates funds for innovative programs and recognizes the unique educational disadvantages by non-English speaking students. Federal law. Supreme Court rulings, 1974, Lau versus Nichols. This court ruling made school districts take affirmative steps to overcome educational barriers faced by non-English speakers. After the court's decision, the United States Department of Education's Office of Civil Rights created the Lau remedies. Whereas Title VII Bilingual Education Act regulations applied only to funded programs, the Lau remedies apply to all school districts and function as de facto compliance standards. The Lau remedies specified proper approaches, methods, and procedures for 1, identifying and evaluating national origin minority students' English language skills. 2, determining appropriate instructional treatments. 3, deciding when limited English proficient students were ready for mainstream classes. And 4, determining the professional standards to be met by teachers of language minority children. 1982, Plyer versus Doe. Under the 14th Amendment of the U.S. Constitution, the state does not have the right to deny a free public education to undocumented immigrant children. Federal court rulings, 1981, Castañeda versus Picard. A major outcome of this case is a 3-pronged test to determine whether schools are taking appropriate action to address the needs of Ls as required by the Equal Educational Opportunity Act. The Castañeda test includes the following criteria. 1. Theory. The school must pursue a program based on educational theory recognized as sound or at least as legitimate strategy. 2. Practice. The school must actually implement the program with instructional practices, resources, and personnel necessary to transfer theory to reality. 3. Results. The school must not persist in a program that fails to produce results. Continuing with federal law, we have now ESSA. ESSA requires reporting Ls with disability, as well as reporting on the percentage of students who are long-term English learners, as measured by students who have maintained the classification for 5 years or more years. Long-term Ls who have not achieved proficiency after 5 years of being initially classified as an L. Dear Colleague Letter, this guidance is referred to as the civil rights laws. When conducting evaluations, school district must consider the following. 1. English language proficiency of Ls in determining the appropriate assessment and other evaluation materials to be used. 2. Districts must not identify or determine that L are students with disabilities because of their limited English language proficiency. 3. Districts must provide English learners with disabilities with both the language assistance and the disability-related services to which they are entitled under federal law. Districts must also inform a parent of an L with an IEP how the language of instruction in the education program meets the objectives of the child's IEP. IDEA and Ls. Under IDEA, a school district must ensure that assessments and other evaluation materials used to evaluate the child with a disability are provided and administered in the child's native language or other mode of communication, and in the form most likely to yield accurate information on what the child knows and can do academically, developmentally, and functionally, unless it is clearly not feasible to do so or provide or administer. This is true even for those English learners whose parents have opted their children out of the program. A student cannot be determined to be a child with a disability if the determining factor is limited English proficiency, and if the student does not otherwise meet the definition of a child with a disability under IDEA. As part of this process, the IDEA requires that the IEP team consider, among other special factors, the language needs of a child with limited English proficiency, as those needs relate to the child's IEP. To ensure that English learners with disabilities receive services that meet their language and special education needs, it is important for members of the IEP team to include professionals with training and preferably expertise in second language acquisition and an understanding of how to differentiate between students' limited English proficiency and the student's disability. Additionally, IDEA requires that school districts take whatever action is necessary to ensure that the parent understands the proceedings of the IEP team meeting, including arranging for an interpreter for parents with deafness or whose native language is other than English. Now, special specific guidelines for ELS. Legislation has addressed the identification and assessment of culturally and linguistically diverse exceptional students. These cases have generated several legal guidelines. The cases are very significant because they address the cultural and social linguistic needs as well as the special education needs of ELS with disabilities. Diana versus State Board of Education in 1970. This case mandated the assessment of students in their native language, IQ tests, etc. Guadalupe Organization versus Tempe Elementary, 1972. This case mandated that students be assessed in their primary language or through nonverbal communication. This case also dictated that an IQ test cannot be the sole criteria for diagnosis of special need and behavior, but must be assessed outside the school location as well. Dercia S. versus Board of Education, New York City, 1979. The results of this case made changes to the procedures for the identification of ELS with special education needs. Most importantly, this case reinforced the idea that schools must use bilingual resources to identify ELS who are in need of special education services and provide non-discriminatory evaluations on both L1 and L2. Larry P. versus Rouse, 1979. The court ruled that the use of IQ tests had a discriminatory effect and resulted in disproportionate special education placement. IQ tests were culturally biased, and there were less biased ways to assess students, such as diagnostic tests, adaptive behavior observations, and developmental and health history should also be used in determining a child's placement in special education. A quick summary of this significant cases. Interpret at all meetings if parents cannot communicate effectively in English. Information for the placement decision must be drawn from a variety of sources: socioeconomic and cultural background and adaptive behavior. IEP team must develop an IEP that reflects the student's linguistic and cultural needs. If it is determined that a cultural and linguistically diverse student is both disabled and has limited English proficiency, for more information, please email me or Ms. Alejandri at our Harrisburg office, or Ms. Bramer at our Pittsburgh office, or Ms. Dudek at our East office. Thank you for watching.